Barry, for that very, very fine introduction, and thanks to Barry and to Patty Zapp for putting together an absolutely splendid conference in a splendid venue with student assistants who are marvelous. And of course, thanks to you, it's the participants that end up really making a conference. And I've very much enjoyed meeting many of you during the events. I sometimes tell my students, never begin a speech with an apology. Or if you like to watch NCIS, Gibbs says, never apologize. It's a sign of weakness. But I think I need to, this one time. This presentation today is focused around the case that you can see there, Miller against Alabama. It's a U.S. case, and the things that are to come of it are going to be primarily applicable to U.S. law, and it's not, therefore, the ideal topic for an international audience. So let me give you some clues as to other ways that you can listen to this presentation. You'll see that Miller is creating for us in the United States the need for a different kind of forensic evaluation or forensic assessment than we've had to do before, a developmental one. And one way you can listen to this is to say, oh, how does one go about thinking through how to develop a new forensic assessment protocol and idea? The other way, of course, is that a lot of this is going to be developmental. So if you're interested in developmental issues, and especially if you're interested in research, we're going to get to a number of points where this area, this new area of forensic assessment needs some research. It needs some people to give us the tools that we need in order to do these. So with that, let me go ahead and talk about Miller, but starting off, not just Miller, because Miller was one of four very important cases that the U.S. Supreme Court heard beginning in 2005, all having to do with juveniles, and they were the first U.S. Supreme Court cases that involved decisions about juveniles since the 70s. So they really struck us and are very important. In the United States, for those of you who may need this preface, adolescents are in the juvenile justice system up to about age 18, their 18th birthday. However, when they're charged with very, very serious offenses, homicide and some others, they are sometimes tried in criminal court. And that's where Miller and these cases come in, because the penalties that they get are those that would be given to adults, given that they're being tried in criminal court. Now, these cases began in 2005 with Roper v. Simmons, which banned the death sentence for crimes committed as juveniles. It's almost embarrassing to say that. We were one of only 3 countries in the world that executed people for crimes as juveniles at the time that decision was made. If you absent the death penalty, our highest sentence is life without parole, no possibility of parole. You're going to die in prison. In Graham against Florida in 2010, the court prohibited life without parole for juvenile non-homicide cases, leaving open the possibility of life without parole for homicide cases as a juvenile. Then came Miller in 2012 that declared that life without parole could not be a mandatory sentence. It had to be decided by the court rather than by statute a mandatory sentence. And then just a few months ago, earlier this year, Montgomery against Louisiana, the court decided that all prisoners currently serving life without parole now for juvenile homicides, which was estimated at over 2,000 in the United States, had to be resentenced You had to go back and re-sentence them, however old they might be. So these cases are remarkable here in the United States for two reasons. One is that the court established in these cases that kids are different. Now, of course, kids are different. We've had a juvenile justice system for that reason for 100 years. But they established it as a constitutional principle based on the Eighth Amendment, cruel and unusual punishment. And that makes it different. That gives it teeth that are going to have a significant effect in a lot of different areas in juvenile law. When sentencing them, the court said developmental immaturity is a mitigating factor regarding their culpability. They can't be sentenced simply on the basis of the seriousness of the offense. The second remarkable thing was the role that our developmental science had in shaping the court's decision. While Roper was being decided, it was receiving from various sources the research that was just beginning to mature on brain development, and that the brain is still developing during adolescence in important ways, and the behavioral research that we were doing on how kids' decision-making processes are different. And they cited those cases, and they made a compelling argument that the court was used, relying on that research. And it was very exciting for us to see the impact of science, of our science, on them. Now, though, we face a different challenge. Two of those U.S. Supreme Court cases, Miller and Montgomery, require that when young people face sentences in homicide cases, courts have to weigh each youth's degree of maturity or immaturity. Now, that's going to call for developmental and forensic experts to provide evidence for the youth's degree of immaturity as potential mitigation. And therein lies the challenge. We've produced the science that helped the U.S. Supreme Court decide that youths should have a mitigation for serious crimes. Now can we provide courts the information they need to address this on a case-by-case basis? Or, putting it another way, what should a forensic Miller evaluation look like? We have very little in the literature at this point. We haven't started putting together models for what an evaluation in these cases should be. So for the next few minutes, I want to walk you through an analysis in search of that. My comments are based on a paper that I wrote with Antoinette Kavanaugh, which will be coming out in August in Psychology, Public Policy, and Law. So, well, the details I can't get into in presenting today will be available to you very, very, very soon. Now, the correct first step, I think, in devising any kind of forensic evaluation, especially one where we're just getting into it and trying to get a feel for it, is to identify what the law wants to know. I mean, adolescents are immature in lots of ways. We can go and throw all kinds of developmental data at them to describe how this particular youth is this way or that way, developmentally mature or immature compared to other adolescents. But what is it about adolescence immaturity that the law would consider relevant, specifically for Miller cases, specifically for mitigation in homicide? That's where we need to start. Well, fortunately, the U.S. Supreme Court gave us some clues. The court identified some factors. We'll call them the Miller factors that explain what's different about kids, why they wanted to make them a protected class. Protected from mandatory life without parole, and protected from sentences based simply on the seriousness of offense, and that we're assigned in some way that recognized that some adolescents are more or less mature. How will we, work that in? And these factors were their explanation for why this is a protected class. I'm going to go through them very briefly right now, because we're coming back to them later, and this is just to begin to identify them. One we're calling the decisional factor. Adolescents have a greater propensity, greater tendency for sensation seeking, for risk-taking, for poor judgment in the heat of the moment. This all has to do with the brain development and behavioral research on decision-making of adolescents and how they're different, that they don't delay as often. They don't necessarily think in terms of long-term consequences. And that was an aspect of developmental immaturity that the court was concerned about. Dependency, that adolescents are more dependent on the influence of family, the influence of older adults during their offending, and especially that they are influenced by negative abuse effects, abuse during early childhood, things they couldn't do anything about. They're dependent. They couldn't extricate themselves from those things. And that those things have some impact on offending and therefore counts for mitigation. The offense context, this was simply saying with regard to those decisional factors and those dependency factors, these often influence their current offense, the one that they're being sentenced for. To what degree did those things play in with regard to the offense itself? Fourth is the rehabilitation potential. Adolescents are in a period of development when they have a greater potential for change, and that should, the fact that they can change should affect our perceptions of them in terms of a protected class. And the final thing was legal competency. Adolescents have lesser capacities to protect themselves, basically, in the adjudication, at arrest, for instance, making decisions about whether to talk to the police, understanding the Miranda rights, stand trial, assisting counsel, that they're at a disadvantage in this regard. So those were the things that Miller used to create a class protected from mandatory life without parole. Now, the court didn't prohibit life without parole. Prosecution can still seek life without parole in juvenile homicide cases if it can prove that the youth is developmentally sufficiently different from the rest of that protected class. In other words, the child is an exception. So Miller hearings are addressing two questions. Is the juvenile eligible for life without parole? That's the first question. If not, then what alternative sentence is appropriate? Now, you might think that, okay, so we take the Miller factors and we jump in there and we start applying them to both of those questions. But one of the main points I want to make, or we make in our paper, is that I think that actually the Miller factors, and indeed our testimony and our expertise, is not going to be used in the first question. Is the juvenile eligible for life without parole? And I'm going to start out by showing you why I think that's so, and then we'll go to the alternative sentences where I do think we can begin to structure our evaluations around those Miller factors and begin to think about how to do it. Now, in both Miller and Montgomery, the court indicated that in this class of immature defendants in homicide cases, those who might qualify for life without parole would be the exception. Indeed, it's said that they would be exceedingly rare, that one of the cases referred to them as the rarest of juvenile offenders. excluding the vast majority of juveniles. So obviously, we're talking about those who might be eligible for life without parole to be a very, very small percentage. And the court used several colorful terms to describe how rare this person was going to be. They needed to be irreparably corrupt. Okay? They needed to be irretrievably depraved and permanently incorrigible. Okay? So, using our discretion, we picked one of these. Irreparable corruption is what we think is going to be the standard is that they're talking about. Now, that means that prosecutors are going to have to meet that, are going to have to make the argument for life without parole by proving that this youth has no chance for change. It's different from difficult to change or less amenable to treatment than some other youth. It means basically a categorical conclusion that the youth cannot be rehabilitated. Now, this is for the prosecution to show, because this youth, as part of that protected class, is presumed to be amenable to treatment. It's presumed that adolescents can change. So the prosecution bears the burden of showing this one is irreparably corrupt. Defense stands back. I mean, it doesn't have to prove the kid can be changed, because that is part of the, being a member of that protected class. Now, how will the prosecution show that a youth cannot be changed? I hope you can read that. The American Psychological Association spoke to this in an amicus brief, a brief that was written for the U.S. Supreme Court in the Miller case, which the court cited. And APA's experts said this: there is no reliable way to determine that a juvenile's offenses are the result of an irredeemably corrupt character. No reliable way. Well, that's a pretty strong statement, so let's see if we can challenge that. How about measures that estimate likelihood of recidivism? And we've developed some fairly sophisticated and valid ways to do that with adolescents. But even a very high likelihood of future recidivism does not tell us whether a person can be changed. It doesn't tell us whether the person might be responsive to some intervention that would alter the likelihood. Okay, how about psychopathy? Persons with psychopathic personality are considered highly resistant to change. We do have measures of psychopathic traits for use with adolescents, but our most recent research indicates the psychopathy measures during adolescence have unacceptable false positive rates when you try to make individual predictions based on them about future psychopathy. Moreover, research has begun to suggest the benefits of certain kinds of interventions with kids who measure having callous unemotional traits, part of psychopathy. Okay, then, how about measures of amenability to rehabilitation? Well, there are such things. There is an amenability to treatment scale in Randy Salikin's risk sophistication treatment inventory, and it can describe degrees of likelihood regarding rehabilitation potential, but there's no research that indicates that its scores would predict categorical failure to respond to rehabilitation efforts. So what's left? Well, the prosecution might turn to the Miller factors and use them in a backwards way, an aggravating way. For example, let's take the dependency factor, the one that has to do with abuse. They might find that this youth had lots of abuse in his life. In fact, he had so much abuse that he's so badly damaged that the damage cannot be repaired. Let's try that argument. Well, it won't work because we already know from some appellate cases that the circumstances of immaturity, this is the way the cases read, that offer mitigation cannot be used as aggravating circumstances in assigning life without parole to juveniles. You can't turn it around. You can't even use the offense context. You can't look at the heinousness of the offense and try to use that. So, and indeed, about 2 months ago, the Georgia Supreme Court affirmed this whole thing, that you can't use these mitigating factors of Miller to turn them around and make them aggravating. Okay, so I think it's quite possible that as developmental experts, we're not going to have much to provide the prosecution in showing that a youth is irreparably corrupt. And the defense doesn't need our evidence in rebuttal because the smartest thing for a defense attorney to do is to simply give the court everything I've just said to you. If the prosecution tries to use any of those means to seek life without parole. I'm going to cut a little part of my speech out here, but I don't even think prosecutors are going to try. I think in a lot of cases they're simply going to back off and say, oh, let's just go for the most serious alternative sentence that we can get. That's especially so because there are some other U.S. cases in criminal court that are Sixth Amendment cases that say that when you're going to go for this high a penalty that's beyond what's allowed, you have to have a jury and you have to do it beyond, you have to prove it beyond a reasonable doubt. Beyond a reasonable doubt, irreparably corrupt. I don't think so. So let's go to the alternative sentences, which is where I was there a minute ago. There we go. What are they? Well, typically, the optional sentence for first-degree murder is going to be life with the possibility of parole. And then the question becomes, when? Because statutes in the U.S., well, Massachusetts, for instance, says life with parole for homicide can, the time that the person can come up for parole is 20 years, no sooner, but can be up to 30 years, and in some other states, 40 years. So you've got this range of possibilities of when the person can come up for parole, and that's where the arguments will come. That's where the seeking mitigation will come. The other way in which it'll come is that sometimes it's homicide plus something. For instance, a firearms conviction. So that there's two charges, found guilty on two things, and there's two sentence lengths. And in some, and what defense will try to argue is the youth should serve them concurrently, together. Prosecution will say, oh, no. Consecutively, you serve one, then the other. And then this mitigation process will start. In one Illinois case this year, the state sought a consecutive sentence in a homicide plus firearms conviction that would have equaled 100 years. Well, defense said, whoa, we're going to appeal that because that's virtually a life sentence. And they did appeal it, and the federal court said, right, that's like a life sentence, and sent the case back for rehearing. So it's for these alternatives to life without parole that the Miller factors are going to come into play. And they're going to be asking, is this youth more mature than most adolescents, less mature than most adolescents, about the same? And this is where the Miller factors, I think, will come into play. And I'm not trying to actually spell out how we're going to deal with each of these Miller factors. I'm going to focus mostly on the problems we're going to have, the gaps, places where we need some help. We need some research. And let's start with the decisional factor. Excuse me. Here Miller was focusing on the propensity, the tendency for juveniles' decisions and actions to reflect what it called immature recklessness, impulsivity, and heedless risk-taking. The tendency for kids not to think ahead, not to think about the consequences, or for reasons of brain development to be more stimulated than their frontal lobes delaying function can handle. Now, there's many psychological functions relevant for assessing decisional judgment from a developmental perspective. It's cognitive and intellectual abilities that are maturing during adolescence, the ability to think abstractly, and therefore to think hypothetically and think forward to what might happen if I do this, working memory, all sorts of things. And we've got many tests of cognitive and intellectual ability with age norms that we can use in this regard. But what do we have that would more directly assess what the court called reckless, impulsive, heedless risk-taking? Well, one possibility is to look at the methods that we used to do the research that impressed the U.S. Supreme Court. For example, we use tools like the go, no-go task, the Stroop color and word test, the Tower of London. These are all measures of impulsive responding and deficiencies in self-regulation associated with immature impulsivity and heedless risk-taking. We also use some self-report, paper and pencil, and interview measures, asking kids to describe their behaviors, describe their perceptions of risk, think through problems. Some of them measure individual differences in consideration of short and long-term consequences, or resistance to peer influence during decision-making. Those methods are promising. I don't know how many of you have tried to use them in clinical situations, but I think we're going to encounter, under good scrutiny, we're going to encounter significant problems if we try to use them routinely in Miller cases. They've been used mostly in research contexts. Some have been researched only with non-delinquent samples. A few have been used in forensic settings where the legal circumstances may produce motivations and affect that could affect performance. Most of them do not have well-developed age-based norms. Most of them have been validated with samples that do not represent the racial and cultural majority found in forensic cases. So that's our first challenge with regard to this decisional factor. We need to get to work to modify these measures of decisional impulsiveness and risk-taking that served us well in the research settings so that they can be used by clinicians, developmental clinicians, in these kinds of evaluations to actually show where a kid is in relation to other adolescents in this heedless risk-taking. Dependency factor. Miller put it this way: children are more vulnerable to negative influence and outside pressures, including their family and peers. They have limited control over their own environment and lack the ability to extricate themselves from the horrific crime-producing settings. And said that one had to take into account the fact that many such youth, early in their lives, on up into their adolescence, were affected by trauma, by abuse, and that it was something they couldn't do anything about. They were the victim. And that created this adolescence as a special class, and that it should be considered with regard to mitigation. The challenge then is identifying traumatic early abuse, but merely identifying early childhood traumatic events is not enough. Almost all delinquent and non-delinquent kids have been exposed to traumatic events, especially at certain socioeconomic levels. From the viewpoint of mitigation, traumatic events are relevant only if they had a longer-term traumatizing effect that influenced the youth's development. So, how are we in that category? Well, we have something to offer. Developmental psychology has accumulated foundational research on the prevalence of trauma among delinquent adolescents and the relation of trauma to delinquency. And in recent years, we've put together a number of good trauma-related tools to assess the lasting emotional effects of trauma. So I think here we still need to look at how these tools work in this context, especially with regard to what's the direct relationship between this and homicide. So there's some research that could be going on there, but I think it actually, by way of tools, by way of how well I think we've thought through some of the issues of trauma and abuse and its relation to delinquency, we've got some possibilities. Let's look at the offense context factor. This is basically asks us to apply the decisional and apply the dependency information for this youth to the offense. Is there any way that it logically could explain or relate to how this offense occurred? What role did the youth's decisional immaturity actually play, or the past abuse and neglect in the offense as it unfolded? To what extent was the youth's decision-making prior to or during the offense related to peer influences, which would be a mitigating factor? How relevant are all these for thinking about the youth's culpability? Now, here obviously we're talking about a theoretical and inferential process. It's kind of like what we do with, the insanity defense, where we're thinking about the role of mental illness in that instance, in the offense itself. But here we're asked to do it with regard to developmental status. The additional data needed for that process is going to be whatever we can discover about the offense event and how it occurred. We'll be most interested in the youth's perceptions of the event, the youth's presumptions and choices, the youth's role in the offense as it unfolded, especially in relation to co-offenders. And a lot of that information will rely on records and on other people's observations, including self-report by the youth. Now, compared to the other two factors, this one has the least structure. And therefore, let's go back to Tuesday's lecture, the greatest potential for examiner bias in reaching conclusions, the greatest likelihood for lesser reliability between examiners, let's put it that way. Information the examiner discovers might often have limited reliability due to the self-interests of those who provide it, the youth cohorts, the police, the parents, whoever it might be. Moreover, how we use the data inferentially involves forming hypotheses without a clear structure, a clear strategy, which, as I say, leads to lesser reliability. I think here what we need is that anything we can do to develop a standardized or guiding structure for this inferential process, for fitting the developmental data in those other two factors to the facts of the offense. Any kind of structure we can build to guide that thought process might be worthwhile in limiting our tendency toward bias, and I exhort anybody whose research is in that area that we need help on that. Rehabilitation potential. Here it refers to, of course, the potential for a juvenile's rehabilitation. The court referred to evidence that most juveniles with delinquency records do not continue their offending into adulthood. They mature out, so to speak. Suggests the need for evidence to compare this youth to other youths on a continuum of rehabilitation potential. That's different from irreparable corruption, which is no chance. This is a continuum and gives us some, I think, some potential to provide some information. But what can we offer? Well, we do have risks and need tools like the YLS that provide guidance for what needs to change, and many of those tools also have a responsivity factor in them. How responsive, well, this is resiliency factors. All of these things can be used to begin to build a picture of where this youth is in relation to other youths in terms of their potential for change. We have tools to assess clinical conditions of youth to the extent that there may be clinical conditions that need to be treated. But it might not be that simple. The fate of juveniles facing alternative sentences for homicide in Miller cases is what? Several decades of incarceration. At best, they're going to be incarcerated 15 to 20 years before they can come up for parole. We have no research on what types of juveniles avail themselves of rehabilitative options under those conditions. When acceptance of educational and therapeutic options in prison is voluntary, when any reward or for rehabilitation is going to be delayed by decades, so there's a motivational factor there, and when the rehabilitation options are not necessarily designed for older adolescents. Our RNR, risk needs responsivity tools, I think, then are not designed to manage that sort of question. They can go part way, but I think we need to do some thinking on that, and we certainly need research on what happens when kids are, and we've got cases, we've got 2,000 cases coming up that have to be reheard. What happened to them when they went to prison as juveniles? What are the characteristics of those who did respond to rehabilitative potential and the characteristics of those who didn't? We need that kind of research to really begin to address this question. Because I mentioned risk tools, I'll just parenthetically note that when you think about these four factors, I haven't found anything that suggests that an assessment of risk of recidivism per se is relevant for a Miller case. If life without parole is not assigned, and it's one of these alternative sentences, the primary question is whether the youth will spend 20 or 30 or 40 years in prison. And we don't have any ability to predict recidivism that far into the future. So I'm not sure that likelihood of recidivism per se is going to be terribly relevant for these cases. This last one I'll basically skip over because I don't think it's going to be relevant, actually. It may have been relevant for the court to set aside a protected class, but the questions of understanding Miranda rights and confessions and constant trial typically are going to have been dealt with prior to sentencing. So that I'm not sure that that's going to have that much effect on our implications for our evaluations, but we need to keep our eye on that. Now, this is my final point, and it has to do with so-called Montgomery cases. Montgomery earlier this year said you've got over 2,000 people in prison for years who were sent there on mandatory life without parole for juvenile homicides. You've got to go back and resentence them. If they're going to be resentenced, that's going to require considering anew whether that youth was irreparably corrupt. And if not, then what developmental considerations should have been appropriate, would have been appropriate in arriving at an alternative sentence. Now, sometimes Montgomery hearings are going to involve people who are 40 or 50 years old. They may have been there a long time. And from the forensic examiner's perspective, that raises the obvious complication that we're going to have to be basically evaluating a person that doesn't exist anymore. We're evaluating that person back then in time. Yes, that person is in front of us now in a more developed status. Will it be of any value to be actually evaluating this person today and trying to infer what they were like then? It's hard to find the research that backs that kind of a thing. There are times, for instance, if that person is now measuring as intellectually disabled or has a mental disorder that we know develops early on in life, and we have records from that early time in their life that show the same kinds of symptoms, yes. Evaluating them now will have some benefit. But in most cases, the current characteristics are going to be less the focus and more who was this person based on old school records, old mental health records, other people's reflections and recollections of what the person was like. And we all recognize the questions that are going to be raised about the reliability or even the availability of that kind of information when the cases are very old. As we start working on ways to resolve those matters, we need to make sure that we know what the law really wants us to do in these retrospective Miller cases. And right now, it's not quite clear. There have been a few appellate cases before Montgomery. There were some states that said, we think it should be retroactive, so we'll make it retroactive, before Montgomery required them to. And in those states, there have been some appellate cases asking this question. When you go back and you're re-sentencing this person who was charged 20 years ago, what is the proper evidence? Is it the evidence that was available at that time? And given the available information, did they make the right decision? Or can you use information from now? Is it a true resentencing, or is it a resentencing in addition to us being, in the future sort of, knowing something? For instance, let's say that this person, 20 years later now, has not been rehabilitated, has been all the time acting out a bad character in prison, terrible record, and so forth. Can the prosecution say, see, back then they were right, this person is irreparably corrupt? Or take another case where the person has been rehabilitated. Can they say, the court was wrong, this person was not irreparably corrupt? Let's talk about science evidence. We didn't know back then. I mean, Montgomery was sentenced in 1963 at the age of 17. We didn't know much about desistance of youth from crime. We didn't know anything about brain development. There's all kinds of things we didn't know. Can science evidence now be used then, even though it wasn't available then? And a couple of courts have said, yes, you can take into consideration current evidence. For instance, the person has been rehabilitated, and you can take that into account. Scalia, one of our Supreme Court justices, who sadly died earlier this year, had a dissent in Montgomery. And he said, of course, what they're going to have to do in those resentencing hearings is to actually do a resentence based on the evidence that was available or that could have been available at the time. But some of these courts are saying, no, you can use current information, and it's an unsettled issue. So we need to keep an eye on that. So let me recap and close. We've examined the fact that whether kids get life without parole for murder will depend on a showing of irreparable corruption, and according to our analysis, forensic, developmental, clinical examiners won't have much of a role to play in those kinds of decisions. We will, though, I think, have a significant role, and indeed, some in this audience have been doing Miller cases in the past couple of years, and are themselves thinking through and sorting out how to do them, and how to use these, how to use psychological data to satisfy these Miller factors. There's still a number of things that aren't clear about exactly how to apply the factors in Montgomery cases until the law sorts out some of those details. But we shouldn't wait around and just sit and watch. For several of those factors that I mentioned, we've considered examples of the need for research to address them better than we can currently. So we need to get to work. Thanks for your attention, and I look forward to your thoughts about some of this.
Hi, thank you for a wonderful presentation, first of all. I was wondering about the Montgomery cases. I'm not a lawyer, but isn't the burden of proof very firmly with the prosecutor to prove that it's irreparably corrupted? And given what you have presented, wouldn't that be very, very hard to prove beyond a reasonable doubt?
Yes, absolutely. We puzzled over this last year before Montgomery came out. even in Miller cases, I mean, a Miller case is now literally a new case, a case that's just been found guilty, and then you have the sentencing. A Montgomery case will be the retroactive ones. In either case, in both cases, it seems like an extraordinary uphill climb. Prosecution will have to bear the burden, we think, simply because that, kids are a protected class according to the U.S. Supreme Court, and so they've got to prove that this kid is the exception, and defense can sit back and say, yeah, go ahead and prove it. As I said, I went through some of the things that I don't think prosecution can use. And yeah, you asked about the beyond a reasonable doubt. There's Sixth Amendment cases in criminal law, Apprendi, Blakely, or Booker, I can look them up if you want to see me later, that establish that in non-juvenile cases, but now they're going to apply if it's juveniles being heard in criminal court, that if you're going for a sentence that's beyond the statutory max, and that would be life without parole for a kid, you have to have a jury trial. And otherwise, they wouldn't have to have a jury trial. And then the jury has to come back irreparably corrupt, beyond a reasonable doubt. Really, really stiff. We don't know, but I think that prosecutors' best bet is just to let that go and try for the highest life with parole that they can get.
You actually answered my first question in regards to the jury ultimately deciding this. I work in Texas. Jurors in Texas, I'm not as optimistic as you are, couldn't be easily convinced of this, potentially, depending on the circumstances. But that leads into my second question, which is, I'm just wondering if you would be willing to comment at all, sort of in very broad terms, about the new DSM-5 limited pro-social emotion specifier and how that might potentially be brought into this. It's very much related to psychopathy, obviously. But do you see that as something prosecutors might be latching onto to try to bolster arguments about some of these types of characteristics?
It's possible, but there's not, what research do we have that really relates to can't ever possibly change. Your other point, though, I find very interesting. I wonder if it's possible that if juries if they do go for LWOP and juries are brought in, that there are some states in which just simply the heinousness of the crime, the jury just can't imagine a person having done that thing. Even that, and it's going to be up to it's actually going to be how good is the defense. Will the defense steadfastly object to any effort by the prosecution to use the heinousness of the crime? The U.S. Supreme Court said, and the defense has to continue to hammer at the fact that it cannot be based on the heinousness of offense. That's clear, exact words in Montgomery and Miller. It's going to be interesting. Yeah. Okay, thank you very much.